Hello and a very warm welcome viewers. You're watching this special presentation of Sansad TV with your host Kriti Mishra. And joining us today is a very special guest, learned Attorney General for India, Mr. R Venkataramani. Sir, welcome to Sansad TV and thank you so much for joining us. So the focus of our conversation today is alternative dispute resolution mechanism to declog India's legal case pendency.
We began talking about alternate dispute resolution primarily because we thought expeditious justice is eluding us. And then the whole elements or what you call the trinities of ADR, arbitration, mediation, conciliations, are different aspects of doing fair justice and quick justice. In some respect, they are fundamentally different. Be that as it may, if every country can take pride by saying that my administration of justice is the most fairest and the most quickest, then one could have probably said we have taken on the credit card of doing administration of justice. How have you achieved this? And then we begin to talk about institutionalizing all these processes. But over a period of time, ADR has come to mean something away from courts and other than courts. And processes where the congestion in the courts, including the procedures which the courts necessarily need to follow, may not have to be, brought in within the system of these three alternate resolution procedures. It's easy to say that, but one looks at the experiences of many countries in this regard. I'm keeping aside for the time being the arbitration process.
Sir.
There have been incremental steps, but I have not come across any literature about, say, a country like England or some of the European countries where litigation is still on the rise, or take United States of America for that example. I have not come across in literature which talks about the peak points which these countries have been able to achieve in institutionalizing these aspects. But you want to look at arbitration as a separate procedure and mediation as yet another procedure with all their independent elements, then we may say internationally followed and enunciated conventions and every country following it up with their own domestic legislations. India has done that. We find there is some important developments. But at the bottom of it all, comparisons must end somewhere. Yes. Because India has several distinctive features.
That's true.
Its population, the diversity, and the growing aspirations of people to seek resolutions in regard to a wide range of problems. And I don't think we can have such institutions of justice which can produce you the most ideal results within the most ideal time possible. Nevertheless, since the Arbitration Act in terms of international conventions have been enacted, we have amended it a couple of times. And to the credit of the government, the new Mediation Act which came in the course of this year is a very promising legislation, though it is yet to really take off in the most empirical sense. So probably we need to invest more time, resources, both human and financial resources, to further institutionalize these two major dispute resolution procedures. Probably some innovative solutions have to be found. So I think to answer this question in the background of all these statements is that India is now poised with all the experience it has at the domestic level and the experiences gathered at the international level, we are poised for very interesting developments.
Interesting developments for sure, sir. But before we set the tone and tenor of this conversation, so you're the legal dawn of this country, but for our audience, if you could please demystify these concepts of arbitration, conciliation and mediation, what are the key similarities and how do we distinguish? Because I think that awareness is very important.
No, by now we have people's understanding of the distinction between arbitration, mediation and conciliations. There's a large number of practitioners in mediation all over our country. Several high courts have taken very important initiatives, and we find in some of the leading high courts, we have practitioners, very well established practitioners, who are into mediation. What began as a very small understanding of mediation, I think has now become as more or less enlarged in his understanding of what mediation is about, and now it will be necessarily different from arbitration. We have, I should say, people coming from abroad teaching in our universities, and our own practitioners going abroad and talking there. So there's a good deal of international communication and exchange of views going on. So mediation ultimately is all about people giving up their talk on rights and to resolve their disputes on an entirely different plane of resolution other than insistence on rights. So mediation is where you let your rights go to sleep, right? You wake up in a different world where you start with becoming friendly and end with becoming more and more friendly. That is mediation, to put it metaphorically, right? Conciliation is a smaller level, right? Where complicated issues are not there and people can sit together and sort out, maybe through some interested assistance or at their own level. But for a good part of it, conciliation has not been so institutionalized, except probably in some governmental dealings, people are called for conciliation. We have a common sense notion that certain class of disputes are good enough for mediation, that is the domestic disputes. Yes. We have crossed that stage now. Mr. Sriram Panchu and the earlier, stalwarts in mediation had given in his books about wonderful examples of how commercial disputes qualify preeminently for mediation and how many of them have been mediated and settled. So any dispute where you don't require the formality of certain procedures, leading evidence, determination of issues, and then using principles of evidence or certain other legal principles, where it is not required or where they can be dispensed with, then mediation is the best way of going about it. In arbitration, we cannot completely give up some of the procedures, and because an arbitrator is a party's chosen representative for looking into the disputes and to hand over an award which is acceptable by both the parties. So there, by and large, these are all commercial disputes, and because they are commercial disputes, question of what is truth, yes, and how much of truth is necessary and how do you reach the truth, there we require still some procedures. So arbitration stands apart.
Well, absolutely, sir, and thank you so much for explaining it in such lucid terms for our viewers. But sir, talking about the challenges of ADR, since you said that we are maturing, how do you see the challenges and how do you see the achievements so far?
When you talk about, we always use the word evolution in anything about life, moving from a stage which is rudimentary to higher levels. So if there is no change and we keep struggling at a certain level, then we say that there is no initiative at all. But I suppose if you look at the arbitration field, we had old 1940 legislation, And at that point of time, even internationally, arbitration was still looked at another closer cousin of litigation. But now we have given up that idea internationally, and therefore, if you look from 1996 onwards, as India moved into a more greater globally connected economy and a certain amount of latitude for enabling resources to come into India and also give them a certain element of security, safety, etc. So India has also entered into a lot of multilateral, bilateral treaties at the international level. By now we have begun to look at them. We have gained a good deal of experiences on these treaty formulations and treaty experiments. So India today is currently inclined to look at some of them and see, therefore, look how domestic arbitration can be enhanced in order to ensure both domestic investment in capital and resources and also international investment can be so placed in the economic order that what you call the ease of doing business is made more visible and more acceptable. So from that point of view, I say that India has taken very important steps. But as many steps you take, then you are chased by a few other challenges.
That's right.
So the challenges which come on the heels of taking good steps, I think sooner or later, with the current initiatives that are on what one may call the dispute resolution runway of the country, right? We may reach some good milestones very soon.
So, sir, what is your experience after ADR? Do the aggrieved parties, one of the aggrieved parties, they utilize their right to appeal? What has been the experience so far?
No, I don't think the right to appeal question can be brought in a generalized way in the context of ADR, because mediation is a process where parties go through a what called a metamorphosis of their own disputes. So no records, formal records are kept there, and no formal orders or awards are passed by the mediators. Appeals do not ordinarily lie against the mediating process. But under the Civil Procedure Code, where a pre-litigation mediation is desirable, and even then, if the mediation fails, it fails. No court goes into an inquiry as to why the mediation failed. When it comes to arbitration, of course, it's a different story. And the story was getting a little unclear in the early years of our Arbitration Act of 1996. So the way arbitrators are getting appointed, the way at interlocutory measures, interim orders are being passed, dissatisfactions on these procedures, and the way High Courts and Supreme Court began to interfere in the appellate procedures. Now I think we have reached a plateau. While we begin to talk about institutionalization of the arbitral process and to be more and more in tune with international procedures, what are we doing? We are looking at the emerging centers of international arbitration. So the world started with London, then Paris, then Singapore, then Australia. Now look at what China is doing. It has set up an international commercial court. So these are matters I'm sure the government is going to look at them very, very closely. And as I talk from a personal understanding of the attention that the government is inclined to give, we should be moving into these directions as early as possible.
So, while we already have the arbitration, conciliation and the mediation acts in place, but perhaps one of the biggest challenges that we have shortage of arbitral lawyers, and arbitration is always given second preference by lawyers. Would you accept that?
Of course it was, because if you looked at arbitration not as a major process of dispute resolution, as we often say, it was a part-time practice. So arbitrators used to sit in the evening, lawyers used to go and practice before the arbitrators in the evening. So your part-time practice cannot be elevated to the height or the status of a real, what we call dignified and an acceptable process of dispute resolution. But that stage is over. And we have, of course, owing to court initiatives, the arbitration process has been molded in several ways. But I suppose the court initiatives also have their limitations. Yes. And if you walk into any High Court bar today, and there is a good admixture of lawyers who do arbitration not as a part-time work, but as a full-time work. So new talents are coming up as expansion of commercial disputes happen. We have the bar also getting involved in it in a more fundamental way. So it's in that context, probably I should inform that a long-standing thought process about structuring the arbitration bar is now coming to a reality. Now, on the 11th of May, we will have the Arbitration Bar of India being inaugurated. I'm sure this will be an important step towards institutionalizing the arbitration process in India, alongside the other aspects of institutionalization.
Absolutely, sir. And while you've clarified in the beginning only that India is very diverse, we have very different conditions, very different demands. But I was just going through the Niti Aayog report of 2021, where it studies the mediation process in countries like Italy, Turkey, Brazil, even England and Australia, saying that at certain stages mediation is made compulsory, whereas in our country it is voluntary. Do you think that we can think in that direction? If not now, maybe in future?
How do you really work out difference between making it compulsory and keeping it voluntary? There is some element of fineness in keeping it voluntary, so that people, when they voluntarily get into that, the reluctance of acceptance of the mediation process will not ordinarily arise. But when there is an element of compulsion, unless, or one can put it differently, if compulsion enters the whole field of mediation, then we may begin talking about the cultural change in looking at, oh, why should I want to go to court? Here is a good friend of mine who will do justice for me. And that means a cultural paradigm shift. If that can arise by reason of compulsion walking into the picture, perhaps one can look at that. Maybe that's what is happening elsewhere. I have not closely studied the impact of the compulsory element in those countries. But I perceive a compulsion can only bring about attitudinal changes, changes in looking at or dispensing with current systems of dispute resolution and so on. So when you talk of culture, so today that also plays an important role in international commercial arbitration.
That's right.
So we have examples. Recently I was reading a book on culture of international arbitration. An example of the three arbitrators, one was a French professor, the other was an English retired judge, and the third arbitrator was a Belgian practitioner. And the law firms were from Washington and Europe. So look at the admixture of Europe, a global combination. And one of the witnesses to be examined was from Africa. So the question was the culture of arbitration. We may have those problems. So culture has a larger connotation, but the more important thing which you wanting me to respond to is that the willingness of people to leave forever, the attachment to litigation as the only way of dispute resolution. This is an attachment which has been with us probably ever since the English came in and colonized us.
Probably, sir. But before we end this conversation, sir, your closing thoughts on strengthening ADR and its enforcement in India?
No, I suppose strengthening all these procedures require a non-political engagement, and I also, by which I mean the central government and the state governments will have to come together and to find out what areas of dispute resolution at the national level and at the state level, and more importantly at the district and the panchayat level, what areas of issues and disputes can be resolved by these other methods. That requires a lot of dialogue, a lot of investments in terms of resources, and as I said, a different set of institution building. It means completely giving up on the court as a model. The court as a model looms large in our mind. So, if you want to have expeditious and meaningful justice, I think it's important that we move away from the court as the only model of dispute resolution. Why I say this is, it's something like which is so deeply entrenched in our psyche, and many of us find it difficult to shake it off.
Well, thank you so much, sir, for such important insights, and thank you so much for such an erudite conversation.
My pleasure.
To watch more programs of Sansad TV, subscribe to our YouTube channel and don't forget to like and share them.